002, People State of Michigan versus Marlon Mason and Cornelius Furman.
Jennifer Douglas for the people, P727448.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Mason and Mr. Foreman, both of whom have been advised that their rights wish to stand mute, waive the formal reading.
We are denied guilty plea. Both your clients?
Yes, Your Honor.
Argument at the bond?
Your Honor, Mr. Mason, the people are going to ask for a bond of $25,000 personal. This is non-assaultive. However, we do have some concerns given that Mr. Mason allegedly tried to flee the location when police were dealing with Mr. Furman. So that's why we're asking for the higher personal bond, $25,000 personal. For Mr. Furman, we're asking for $25,000 personal, but we're also asking for a tether. We believe that Mr. Furman has demonstrated that he is a flight risk and that he does actually have a pending case right now where he failed to appear. I'm trying to see where I wrote which court this is.
You're asking for personal bond for both of them?
Yes, Your Honor, but on Mr. Furman, I'm asking for a tether. He's got a pending case where he failed to appear at circuit court. And then I see it looks like he's got a current HIDA probation out of 44th District Court.
Can I ask him? Can I talk?
No, you cannot talk. Did anybody ask you a question?
No, I was trying to.
Okay, well, please be quiet. Ms. Kirkland, can you address the issue of tether, please?
Yes, Your Honor. So regarding the tether on Mr. Foreman, I'm asking that the court not impose a tether. Mr. Foreman is 19 years old, lifelong resident with one child. He lives with his mother. He has strong ties to the community. He has no assaults and convictions. I'm asking that the court give him the opportunity to appear on this case. It sounds like he does know how to show up to court.
Hold on. What are you doing, sir? You waving your hands like you in church.
I'm just nervous. That's all it is. Like, I've come to court like every time.
Okay. Judge, can I say something to him? Judge, can I say something to him?
I'll put you both in a quick breakout room.
Okay.
Yeah, because he's bothering me. Okay, Ms. Kirkland, can you continue your argument as to bond, please, as to the tether?
Yes, Your Honor, I am asking that you not.
Hold on 1 second. Okay, continue your argument as to the tether, please.
Thank you, Judge. I'm asking that you not impose a tether. I'll start with Mr. Foreman. States that he's always appeared at his court hearings, that he's never failed to appear. So I'm not sure what APA Douglas is looking at. What I can say, Judge, is that we know that he's successfully completed, probation before, which shows that he does know how to appear with court and comply with court order. So I'm asking that the court consider that. In addition, like I stated, lifelong resident, has a child, lives with his mother, so he has strong ties to the community. I'd ask that the court give him an opportunity to appear on this case.
And Your Honor, I can tell the court what I was looking at. I was looking at the Register of Actions on my court, and then I went to the Ingham County Circuit Court website, looked at that Register of Actions. He first failed to appear at a PCC August 24th of 2023, where he was given a cash bond. He had a personal bond. He's arraigned on that bench warrant September 20th of 2023. The bond was reinstated back to personal. He waived his exam and he was bound over, but then he failed to appear in circuit court on January 8th of 2024. And at least according to the Register of Actions on the Ingham County Court website, he's not shown up again to court after that. So that's where I'm getting that from.
Ms. Douglas, I'll let those courts. No, Ms. Kirkland, I'm ready to rule. Ms. Douglas, I'll let those courts deal with those non-appearance issues. I am going to adopt a $25,000 personal bond for both without a tether. While this case is pending, gentlemen, you're not to possess any handguns, either of you. Probable cause June 18th, preliminary examination June 25th, both in front of Judge Jefferson. Step aside, please.
Thank you, Your Honor.
Mr. Mitchell, you got some traffic matters which you failed to appear in court for, sir. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants. Your personal bond in this misdemeanor matter carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The ticket in question is 185143851. August 16, 2018. Open alcohol and motor vehicle. Your new court date, pretrial, July 12th, in front of Judge Michael Wagner. Is that clear?
Yes, sir.
All right, now to your main matter. Calling case number 240-574-3201. Please say the Michigan versus Laquan Mitchell. Appearances, please.
Good afternoon, Your Honor. Lisa Coyle appearing on behalf of the people.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Mitchell, who has been advised of his rights, wishes to stand mute and waive the formal reading.
All right, court, a not guilty plea on behalf of your client. This is almost a 5-year-old case,
It is.
and it just got signed last month, huh?
It did.
Okay. All right.
My-
Argument at the bottom.
I think there was investigation as to the shirt. That is,
Okay.
I read some of the notes. I'm not quite sure what was going on. But the matter, Your Honor, is extremely serious, not only to the victims, but a flight risk as well. So I'm going to let the court know that, as you could have read, and you always do, the danger is to both the complainants in this matter, Ms. Ming and Mr. Kelso. This occurred I have the court note at 3:25 in the morning, in which a Molotov cocktail was thrown through the front window. There's strong evidence that this is the defendant that threw that Molotov cocktail through the window, as well as set the victim's car on fire. Apparently the victim had broken up with the defendant right before
Mrs. Coyle,
occurred.
Mrs. Coyle, I just got one question for you.
Yeah.
Since 2019, has there been any assaultive or harassing or threatening contact between the parties?
There's no notes in PBK, so I don't know. I cannot say. So I can't say anything to that effect, Your Honor. But I do know
what is the bond recommendation you have?
Okay, my bond recommendation is based on the seriousness as well as the flight history. It's going to be for a $500,000 cash bond, tether, house arrest. And I know it's a 2019 case. Yes. But the evidence is extremely strong because there's many admissions that he's making to not only setting the house on fire. And I think the court should note that she bought him a phone. And so she recognized his number, and that he called, and he knew that not only the victim, the second victim, the male, that the kids were also at home. This is like at night. So he texted her, your baby daddy is going to die, and then he hung up. And so she had conversation with him regarding knowing that the man was at home. So then it's 3:20 in the morning, he goes over, there's a Molotov cocktail with his work shirt, allegedly, a shirt that he's been photographed in, and also the company name is on that shirt. So I think that shirt is going through testing, is what I could tell from the note, Your Honor. But what I want to note to the court, I do note, since this occurred, there was a 2021 larceny from a person. He also has a pending CCW FIPFF case in Third Circuit before Judge Edwards. He had on March 6th a failure to appear, on April 3rd, a failure to appear. And for his jury trial date on May 28th, he failed to appear. So for that reason, Your Honor, I'm asking for a high cash bond, no contact with that home if they still live at that residence or any of the victims in this matter, as well as the tether, house arrest.
Okay, thank you. Ms. Kirkland?
Thank you, Your Honor. So, Judge, I'm asking for a personal bond in this case. I'm not objecting to a GPS tether. I would ask that the court not impose house arrest, and at the very least, that the court allow for a curfew for him to attend work. He is working at Burger King. Judge, I'm asking for a personal bond. One, to begin, because this is a 5-year-old case. Miss APA Coyle just listed off a bunch of things that seem to be pretty strong pieces of evidence, but I think if it were a slam dunk case, it wouldn't have taken 5 years to sign the warrant. He is a lifelong resident with the child. I understand, even though he has not failed to appeal on this case. I'm not objecting to the GPS tether, understanding that he has failed to appear on another case. I would ask for a personal bond because this is an older case. At this point, there's no amount of bond he can afford to pay. In addition to that, Judge, he has no assaultive criminal record.
Okay. Court having heard arguments to bond. I understand Mrs. Coyle brings up great points. The allegations are very, very serious and very, very concerning to the court. But to Ms. Kirkland's point, these are 5 years old, and there's nothing to indicate anything of a threatening nature, harassing nature between the parties in this matter.
Your Honor,
I understand.
I'm sorry to interrupt, but I know before you rule, I do want to note, and I usually don't mention cases that are under review, but I do notice that he has 2 cases pending under review from the offense date 6/6 is probably why he was arrested and why he's in custody right now on aggravated domestic violence, as well as there's another case under review from back in February of 23 for an aggravated domestic violence. I know they're under review. I know that, but my guess is the 6/6 case is why he's here today. But it is both assaultive matters. I can't say that there's charges issued, but they are pending in review.
Okay. All right. The court having an argument as to bond, given that this 5-year-old case, there doesn't seem to be any instances of any between the parties, I'm going to give him $100,000 personal bond. Now, to your point, Mrs. Coyle, I'm going to have him fitted with a GPS tether, 9 a.m. to 6 a.m. curfew to assure he comes to court. No contact with Pierre Kelso, Tabitha King. You're also not to possess any handguns, firearms, or other dangerous weapons while this case is pending. Do you understand that, sir?
I'm sorry, can I instead of getting a tether, because I can't even right now my residence is
No. Probable cause June 20th. Preliminary examination June 26th. Step aside, sir.
I'm good.
Thank you.
Thank you, Honor.
Woo. All right, recalling case number 240-576-2601, People City, Michigan versus Cinnamon Rig Maiden. Ma'am, state your name again for the record.
Cinnamon Rig Maiden.
All right, appearances, please.
Deanna Livingston, behalf of the people, P69721, Your Honor.
And Your Honor, Mark Lakin, P41147, on behalf of Ms. Rig Maiden. Your Honor, I'm making a limited appearance. The family is scampering to retain me today, so I'm going to trust that that's going to happen.
Okay. Waive formal reading, stand mute, Mr. Lakin?
We do. I have a copy of the charges. Yes, we waive formal reading. We'll stand mute.
All right, court, a not guilty plea on behalf of the client. Are you asking for a remand, Ms. Livingston?
I am, Your Honor.
Okay, proceed with your argument, please.
Your Honor, given the seriousness of these charges, given the number of the victims, given the danger of the community, and given the high likelihood of conviction in this case, the people are asking for a remand. As I'm sure Your Honor is aware, as stated in the investigator's report, this defendant decided that she wanted to make her ex-boyfriend, quote, feel her pain, which she was able to do on the 3rd of June. She deliberated for at least 2 to 3 hours beforehand. She then decided she was going to go to a gas station, purchase 75 cents worth of gas, drive over to the location, approach the home with the gas in her hand. Upon getting onto the porch, she then poured that gasoline onto a couch that was located on the front porch. She did this with knowledge that the uncle of her ex-boyfriend was in that home, as he had previously turned her away a half hour ago. She did this with knowledge that the uncle's fiance was in the house. She did this with knowledge that the ex-boyfriend's mother, who is paralyzed on the left side of her body and has limited mobility, was in that house. And then she set that couch on fire. She then left the home, but she did not leave the location. She sat in her car and picked up her phone. She did not call 911. Instead, as the house is burning with the people inside, she texted her ex-boyfriend and said, "Your house is on fire." She then left the location and went to McDonald's. And then it's alleged that she, per her own words, purchased cocaine. The consequences of her actions that night caused the fiance to have to jump out of a second-story window to not have any more smoke inhalation, which upon landing on the ground, she fractured her ankle. The uncle had to flee the home to not suffer any more smoke inhalation, but not before he had to make the decision to leave his paralyzed sister in the home. The victim in this case, who I've already stated her limited mobility, was able to climb out of her room and made it to the stairway second floor landing, where her body was found burned. She had suffered numerous burns over her body and smoke inhalation. Not only did the Durrell family and Miss Johnson suffer, the house next door also caught on fire because this blaze was that bad. Therefore, Judge, I believe the only appropriate bond in this case is a remand. And I would also like to note to Your Honor that I was just made aware she also has a prior that is not listed on the warrant for uttering and publishing from 2016 out of the Sixth Circuit, which she was given height of probation for, but apparently it appears that was revoked as well. So I'm asking Your Honor to remand us the defendant for the reasons that I have stated thus far.
Thank you, Ms. Livingston. Mr. Lakin?
Let me just make an inquiry as to what year the Oakland County case was.
2016.
All right, so it's 8 years ago. She would have been 23 years old at the time. Your Honor, obviously the prosecution has more knowledge of the facts that they present today. I have not had the benefit of reading a police report yet. I don't think that any actions were meant to harm anyone but property. And unfortunately, there were some deadly consequences here. I know her as someone who has no criminal record, which she does not have if she got. So that's our position. Our position is that she was interviewed by the police and cooperated in every way possible to her benefit. This investigation is basically, they know what happened here simply because she completely cooperated with the investigation. So she is entitled to some sort of a bond without a prior record. Obviously, something has happened here that went badly. So, but I don't believe that she intentionally meant to hurt anyone, except some property. So that's our position. We'd ask you to give her a bond.
Okay, court has heard an argument as to bond under M. People requesting under Court Rule 6.106 a remand, which is allowed based if the defendant's guilt is evident or the presumption is great. And Ms. Livingston presents an argument that the presumption of guilt is great in this matter. Accordingly, and given the egregious nature of this offense, the court will remand Ms. Rigg-Maiden to the custody of Wayne County Jail while this case is pending. Probable cause June 14th in front of Judge King. Preliminary examination June 20th, 1:45 p.m. both in front of Judge King.
Thank you, Your Honor.
Thank you.
Step aside, Ms. Rigg-Maiden.